what they are tonight.
I believe that's the intent of this history.
So really, we can begin by just noting that Title 18, Chapter 5 of the Wyoming Code contains the statutes that grant counties planning and zoning authority and prescribe limits of that authority. In this present case, this proposal, we only need to focus on Article 2, and specifically 18.5201 and 18.5207. It is also important to note that counties have no sovereignty independent from that of the state, and the only power available to them is the power that has been delegated to them by the state. Thus, a county's authority to adopt a zoning ordinance is limited by state statute, and the general grant of power to counties to adopt zoning laws in the interest of public welfare does not permit the local governing bodies to override the state law and the policy supporting it. If an ordinance conflicts with a state statute, then the ordinance is void. That's right from the Supreme Court. We recognize that 18.5201 permits counties to regulate and restrict land uses in the unincorporated areas of the county. This zoning authority has limits. One limit is that this authority must be exercised in a manner that promotes the public health, safety, morals, and general welfare of the county. Furthermore, when a county issues a resolution pursuant to those ends, it must be reasonable means to implement the regulation. Now in section 18.5207, it contains another significant limitation which contains some ambiguity. The first sentence reads, a zoning resolution enacted under the provision of Wyoming Statute 18.5201 through 206 shall not prohibit the continuance of the use of any land, building, or structure for the purpose for which the land, building, or structure is used at the time the resolution is adopted, and it is not necessary to secure any certificate permitting for such continuance. While 18.5201 grants counties general zoning authority, 18.5207 circumscribes that ability by permitting the continuance of uses that predate the adoption of a legal zoning resolution. It also examined this limitation as a non-conforming use exemption and or a grandfather exception. Now the Supreme Court defines a non-conforming use as a use which, although it does not conform with existing zoning regulations, it did exist lawfully prior to the enhancement and enactment of the zoning regulations. These uses are permitted to continue, although technically in violation of the current zoning regulations, until they are abandoned. An exception of this kind is commonly referred to as the grandfather exception. This sentence of 18.5207 recognizes the right to continue a non-conforming use as a vested property right. This is protected by both federal and state constitutions. Second sentence in 18.5207 gives counties zoning authority over certain non-conforming uses by creating a permissive exception to the grandfather exception contained in the first sentence. The second sentence reads, however, the alteration or addition to any existing building or structure for the purpose of effecting any change or use may be regulated or prohibited by zoning resolution. Section 18.5207 unambiguously gives counties authority to regulate or prohibit alterations or additions to grandfathered buildings or structures when the alterations or additions creates a change in the use of the grandfathered building or structure. It says nothing about changes in use of grandfathered lands. I would just say that I really believe, in this proposal you give a definition of non-conforming grandfather. Well, you just heard the definition by the Supreme Court after reading the two statutes, so I'm hoping we're all in agreement where that's sitting. I believe that this proposal is in direct opposite of what the statute and what the law, what the legislature has written, what the justices have upheld. And I really would advise that you withdraw this proposal and just stay with the way we are right now, because I think this will be against the statutes and it will become null and void.